So now we know there are many different types of deeds. Now it's time to take a look at what are the characteristics of a deed. What kind of information can you find in the deed, and why is this important? Now, you recall all deeds do the same thing. That is, they convey property rights, ownership from one person to another. And most of the deeds tend to have the same information. In fact, they probably kind of look the same. Again, the only difference is, depending on the type of deed, is the extent of guarantees and warranties you get. But if you were to print out a deed, and by the way, let me just say this. If you want to be very successful in representing your clients, and I hope you do, then I'm going to suggest you do something that I don't think very many real estate agents do. Quite frankly, a lot of veteran agents. But there's at least 2 documents, and maybe even 3, I think you need to have in your hands before you list a property for sale, if you're representing the seller, or if you're representing the buyer. You need these same documents in your hands before you write up the offer. There's just a lot of critical information you need to do either one of those 2 things. One document you need is the deed. You got to get a copy of the deed. If you're listing the property, there are a lot of things you need to know about what's in the deed. But one, you need to know who owns the property. I've actually had sellers tell me that, obviously they say they own the property, and then find out, that maybe they do own it, but they're not the sole owner. There are other owners. And then I've had others tell me that, I own it. Well, they do, but they don't own it in their name. They own it in some business entity. And, when you write up the contract, you can't put it in the person's name if it's deeded to a business entity, right? So you could save yourself so much grief by having this deed right in front of you. So if you're the buyer's agent, same thing. You need to know who owns the property. Are there any deed restrictions? And I will tell you, where are you going to find the deed restrictions if there are any? In the deed. So you need a copy of that deed. You also need a copy of the plat, the survey. I won't get into all that right now, but for now, you need the deed. And so let's look at the information that you would have at your disposal if you had a copy of the deed. Let's say you're representing the buyer. And let's see if anything that they list here in the deed might be of importance to the buyer. Well, the very first paragraph of the deed is called the premises paragraph. That's where you're going to find both the names of the grantor and the grantee. It'll list who owns the property. If there are multiple owners, it will show who all the owners are. I'm just telling you, a lot of listing agents, they will list the property and they may only think there's just the one owner, when in fact there are other owners. And you can't sell the property with just one owner signing documents. They all have to sign, right? So you got to know who are we dealing with here. Any explanatory facts, any facts about the property that are significant, you'll find in this paragraph. But you'll see also this granting clause. I will tell you that's something they probably could ask you about for sure. What is a granting clause? Obviously that's just a clause in this paragraph that expresses some words of conveyance. If I'm selling my house to John Doe, then you'll see a clause or a sentence in this premises paragraph says, I, Frankie Griffin, hereby convey all ownership rights over to John Doe. Y'all, that's just some words that express conveyance. Y'all, that's called a granting clause. I remember that for sure. Y'all, whatever the consideration was, you'll be able to see that. Y'all, typically valuable consideration. So you can see exactly what the seller paid for that property when they bought it. Okay. Now, if it was no valuable consideration, then it would have said love and affection. Y'all, that would be the invaluable. But whatever the consideration is, y'all, you'll see it there in the deed, along with a adequate legal description of the property. Y'all, and I get, y'all, this is another big deal, especially when you're practicing real estate. Y'all, you should never, in a contract to sell or a listing agreement or any other real estate paperwork, you should never just put the address. Y'all, I'm telling you, it is not uncommon that the address that even the homeowner thinks the address is, y'all, it may be wrong. So you need to have, y'all, you want to put the address, but then you also want to have the legal description, y'all, the lot, the block, subdivision, y'all, if it's applicable. But there has to be a legal description along with the tax map number. Y'all, all that information is right there in the deed. Okay? So when you're listing the property and you don't know where to find all this information, y'all get the deed, right? You need a copy of this deed, whether you're listing the property or whether you're helping a buyer make an offer on the property. Y'all, a lot of the information you're going to need to go in these documents, you'll take straight from the deed. Y'all, otherwise you can be spending a lot of time doing addendums, fixing stuff because of in the contract because you put stuff in there that was wrong or not right or something. So anyway, so that's the first paragraph, the premises paragraph. The next paragraph you'll see in the deed is called the habendum paragraph. Y'all, the word habendum just means you have the right to have and to hold. That would probably be something good to remember as well. What does habendum mean? The right to have and to hold. But in this paragraph, you'll see what type of estate is being conveyed. Is it a fee simple? Is it a fee simple absolute? Is it a life estate? Y'all, whatever it is, y'all, you'll know it's right that it'll state that in the deed, right? Any conditions that affect this grant or conveyance, y'all, that's the restrictions. Y'all, if there are any deed restrictions, y'all, for example, it might say you cannot have farm animals on this property. Then you better not have any animals on that property or you risk losing the property. Y'all, so you want to make sure there's no conditions or restrictions in the deed that the buyer can't live with, okay? And then obviously covenants of title, all of that will be in the habendum paragraph. I mean, again, the right to have and to hold. And then the next paragraph is called the testimonium paragraph, and that will be the date that the conveyance takes place. That's also where you're going to see the grantor's signature. Remember, the grantor must be competent. But what about the grantee? Y'all, what about the buyer? Does the buyer's signature go there? No, remember, the buyer does not sign the deed. Only the seller or grantor signs the deed, because once they sign it, again, because of that granting clause that was in the first paragraph, that premises paragraph, y'all, it says, I conveyed this interest to so-and-so. Y'all, once they sign it, then that interest has now been conveyed. And then obviously you would need and want a witness to basically stating that this is the seller and the seller did sign this deed, right? So the next thing we need to understand about the deed, the deed would need to be acknowledged, okay? Now, what does acknowledgement mean? It means it has to be notarized. It's kind of where the witness might even come in. Y'all, the notary might serve as the witness. But if you're at the closing table, y'all, oftentimes you'll see where, right at the end, once pretty much all the documents have been signed, the last thing that's got to be signed is the deed. Y'all, the seller will sign the deed over to the buyer. Well, a lot of times, y'all, the attorney or whoever's conducting the closing, y'all, they'll call in their paralegal or somebody will come in to actually witness the seller actually signing the deed. Now, how do they know this is the seller? Because when you go to closing, you got to bring identification, ID, driver's license, something to prove that you are who you are, and they're going to have a copy. They're going to get a copy of your license and all that stuff. But then once you signed it, then this person will then go ahead and notarize the deed. And so what does acknowledgement mean, or what's the requirement for acknowledgement? Y'all, acknowledgement means it's being notarized. Y'all, is to certify the genesis of the grantor's signature. Y'all, that's what acknowledgement is. Y'all, that's what a notary does. Y'all, they certify that the grantor or seller is who they say they are and that they actually signed it. It's just the words that you might want to get used to. If they should ask you, what's the purpose of acknowledgement? Is to certify the genesis of the grantor's signature. Okay? Y'all, and by the way, when you go to record the deed, y'all, it has to be acknowledged or notarized. Y'all, you cannot record anything, to my knowledge, in the public record that has not been acknowledged or notarized. Okay? Y'all, and by the way, before we leave that point, y'all, if they should ask you the purpose of acknowledgement, be careful with this one, because y'all, one of your possible answers might be so that it can be recorded in the public record, so that it can be recorded. That's true. It does have to be acknowledged or notarized in order to record it, but that's not the purpose of it. Y'all, what's the purpose of acknowledgement? To certify the genesis of the grantor's signature. So don't let them trick you or hurt you on that one. Be careful there. Then there has to be a delivery and acceptance. In other words, once the seller signs the deed, they usually, if you're all sitting down at the same closing table, you just get it right then and there. And assuming the buyer accepts it, it's a done deal. It's valid. Buyer, welcome home. It's always a happy time, for sure. Okay. Now, when it comes to actually recording the deed, y'all, first of all, do you have to record the deed in the public record for that deed to be valid? And the answer is no. Now, you probably should record it, but it doesn't have to be recorded. Well, there's 3 types of notices you need to be familiar with or aware of when it comes to recording the deed. Y'all, the first is what we call constructive notice. And constructive notice just means we have recorded it in the public record. It's now recorded. Basically, now we're saying this is now my property, not yours. You stay away. That's constructive notice. It's recorded. But you could just provide actual notice, which means you've chosen for whatever reason not to record it in the public record. Y'all, even though it's not recorded, y'all, it's still legal and valid. Y'all, as long as it's signed, acknowledged, y'all, it does not have to be recorded for it to be legal and valid. The problem is nobody knows who owns. Y'all, there's nothing in the public record to suggest the new buyer now owns the property, right? Y'all, people do stuff like that from time to time, and I'm telling you, this is where you could potentially have defects in title pop up, where somebody might have gained interest in the property, never recorded it, so therefore it was not known to the public, and then we move forward doing different things, unaware that there was another owner of the property. So that's where these clouds and issues, title issues, can come from. Another reason why you want title insurance. You never know what has happened here. So constructive notice means it's recorded in the public record. Actual notice means it is not recorded in the public record. Y'all, they're both legal. They're both valid. Just one's recorded, one's not. And then, y'all, this third one, inquiry notice, y'all, it's a little bit different than the first two. But basically, y'all, obviously, if you're signing a legal document, don't you think you should bear some responsibility to ensure you understand what you're signing before you sign it, especially if it's a legal document? Would make sense to me. And y'all, what they're saying here is, y'all, before you sign any legal document, but in this case the deed, you are afforded inquiry notice. Meaning, y'all, if you don't understand something in this document, you need to inquire into it. You need to start asking questions. What does this mean? Before you sign it. Because, y'all, once you've signed it, it's done. You can't come back later and say, but I didn't understand that. Oh, well, too late now. You had your opportunity to inquire and you chose not to. So anyway, so those are your types of notice. Now, I did say that, I think you need to record the deed once you close. I think it's very important to do that. Obviously, legally, you don't have to do it. But why is it important? If you look at that second bullet there, it says for you to be covered to protect yourself from future claims on the title, you should record the deed. Now, if they should ask that question, why should you or why is it important to record the deed? I suspect the answer they're going to be looking for is to protect yourself from future claims on the title. So, you need to record the deed. If it's not recorded and all you've got is that piece of paper, the deed, the physical deed in your hand, you better hope you never lose it or it never gets destroyed in a fire or something like that, because that's the only proof or evidence you have of ownership. So you're taking a really big risk here, in my opinion, not to record the deed. Again, that's the only proof you have of ownership. But if for no other reason, you want to record it, so you can protect yourself from future claims on the title. So those are the characteristics, the information you would find in the deed.